Mame kwa homa so ye na anim say ye mame Isaba Tokono or ye former Chief Justice and as ye Chief Justice Sabrede Bamino or battle court case ye per se ye free horror ni remove no na enkofo bi di court say e kwan yo man pani fa so a oyi mame no e de free horror and especially suspension no omontiase to omo de koda Supreme Court say Supreme Court nka bi mo omo na kwan ye fa so the processor ye di yi mame no Supreme Court nsa reverse no but enwa normal ankoye amfa mo de sade ne edeko ne sabre me wo lawyer Raymond Bidima ewa homana so oye law lecturer ewa CAF University ewa homana so lo be mo akwa ba o.
Oh, good morning. I tell you saying
nyako pada ro ma bibia boko.
Okay.
Na law ka che you a decision here by a 4-1 decision, right?
That is correct.
Okay, good. So does it mean say yenya justice?
This decision is actually expected. I was even expecting unanimous decision in this case.
That's a 5-0.
I was expecting 5-0.
Oh, okay, Adientra.
The question again?
Adientra now we're expecting 5-0.
You see, there are grounds on which a court will grant an injunction. And if you look at what the petitioner was alleging, the grounds on which the petitioner went to the Supreme Court is not folded in law. The Constitution is very clear as to what should be done in the matter of a petition for the removal of the Chief Justice. And in this instance case, all the procedures that has to be followed in order for the Chief Justice to be removed, the President is acting according to the dictate of the Constitution. And so if a party goes to court, it is not about emotion. It is about what the law says. And I quite remember the Chief Justice once upon a time said, the law is the law. And if the law says that once a Prima facie case is made against the Chief Justice, then there is that opportunity for the President either to suspend the Chief Justice or allow the Chief Justice to say, pending the determination of the matter, if the President goes ahead to choose one of the two options that are available, what is wrong about it? What is wrong about it? It is only that the Constitution provides that a person goes to court, and that is why they are exercising their right to go to court. Other than that, for me, it is founded on nothing but just emotions and nothing more.
Okay. So in this case, as a law lecturer, what should be the next step? What should be the next step?
I listened to the interview granted by the CEO of the group, and he said he wants to consult with his lawyers, and as the case may be, he will take a step from there. Now, there is one more available remedy for him, which is for him to, as the case may be, go and seek for the judicial review of the decision, where in that case the Supreme Court will be made up of 7 judges to sit on the matter to determine same. I don't know, but it is his constitutional right. He may want to take that option, but like I said earlier on, for me, I don't see the visibility of it because it is unmeritorious.
So this is the second time that the Supreme Court has dismissed an injunction application seeking to, halt the impeachment process. The first one came from Tafo Pankrono, old Tafo Pankrono, member of Parliament, which is Honorable Vincent Assefuwa, and this one. And today we also heard that the Chief Justice herself has also sued. The whole process. Do you think that the Chief Justice would get a justice judging from the two the precedent that I talked about?
It will depend on what you term justice. For me, whatever comes out of the court is justice. And so, depending on where one particular party may be standing or where he is coming from, that will determine whether he or not he has gotten justice. And the courts are there at all times to make justice. And so, for me, like I said, not to prejudice the matter before the Supreme Court filed by the Chief Justice, but like I said earlier on, there are grounds on which a court will grant injunction. And I don't think, if any at all, the Chief Justice will be able to scale that threshold for which reason an injunction will be granted.
Madam Gertrude Tokono is saying that when the Prima facie case was established by the Council of State as the Constitution 146 states, he was not served. He was not served. All what he heard is that the petition was all over on the radio. Everybody was talking about it. So he is, going to court, seeking, going to court to, halt his suspension, because he thinks that what was done was not, in the line of the law.
You see, we need to, for the purposes of your listeners, we need to appreciate something here. What is Prima facie case? Is it a judicial process? For which reason maybe natural justice issue may arise? And the answer is no. The answer is absolutely no. It is not a judicial process. What Prima facie case means is that on the face value, taking into consideration what is before you, do you think that there are legal issues contentious enough for the determination of a panel or for the determination of a court? If yes, then the judicial process starts. That for the determination of Prima facie case, it is not a judicial process where one will say that he has not been given fair hearing. And in any case, I could recall at the time when the Chief Justice wrote to the President has given her 10 days in order for her to actually respond. And so I don't know what is about the natural justice, right to be heard has not been complied with. For me, I think that at this point, it is not, or that issue of natural justice cannot arise, because it is not a judicial process where a party will have to be called upon to come and justify or come and respond. It is not enough. Actually, if you look at the Constitution, it is if you ask me, I can tell you it is like a shield that is used to protect or against a petition or frivolous petitions. You know, if there is no shield that is to be used in sieving this sort of petitions, then at any point in time where a person presents a petition, whether it is meritorious or not, there will be the need for the empanelment of the justices or to hear the matter. And I don't think the framers were wrong when they say that there should be establishment of Prima facie case, because there is the need for the petition to be vetted on the face value, so that they do not go along to waste everybody's time.
Okay, so now the woman herself seeking to declare the process leading to her suspension as the null and void, and it should be set aside. That's as reported by the delegate today. It's the same thing that the civil society groups and Honorable Vincent Asefua sought for. Now, do you think that what is the woman looking for? Tell us, what do you think that she's looking for?
She wished that she could revert her suspension.
And according to her, the process is unconstitutional.
What is unconstitutional about the process?
He's saying that she's saying that she wants the declaration or that upon a true and proper interpretation of Article 17 clause 1 and clause 2 and Article 19 clause 13 and the fourth clause 14, 23, 146 clause 7 and 8, Article 281 clause 1 and Article 295 clause 1 of the Constitution. According to the woman, the process that the process that they use to suspend her is unconstitutional based on these articles and provisions.
My brother, you see, I could recall vividly during the vetting of the CJ, one of the things that she proposed was that when she comes, she is going to make sure that certain provisions of the 1992 Constitution are amended. You see, the Supreme Court cannot take a case like this one in amending the Constitution. There are procedures for the amendment of the Constitution, and those procedures must be followed at all times. So, what for me, Madam sought to do at this instant case is to amend the Constitution to suit what she wants, which I don't think that the Supreme Court is clothed with the capacity to be able to do. The Supreme Court cannot amend the Constitution with a case at hand like this one. And that is exactly what she sought to do. What is the law as it stands? As at the time, we call something vested right or accrued right. At the time the matter came up, what was the law? What is in the Constitution? That is what is going to be used in the determination of the matter. We cannot, at this stage, amend the Constitution in order to suit. Yes, there may be provisions of the Constitution that may seem to be unconstitutional, but once they have not been declared by the court or they have not been amended, they still exist as relevant laws of the country. And that is exactly what is happening. For me, again, I feel that the in-camera hearing has overlooked its existence and that there should be the need for the change where the hearing must be made public in order to prevent the various people coming to allege or make so many unfounded statements. You see, if this was to be in public domain, people would have been able to identify or see whether or not the lady is wrong in the first place. So like all these about it is not right, some people bringing certain petitions in the public domain and would have prevented all this. Everybody would have known what is happening. For me, I think that it is a clarion call for these statements or these provisions of the Constitution to be amended. But so long as they have not been amended, they still remain the relevant laws of this country.
So you said, tell us, you as a law lecturer at the CAF University, a renowned lawyer in this country, tell us, per what you have read, I'm talking about the Prima facie case established by the Council of State against the Chief Justice. Do you think that the Chief Justice should be removed based on what you have read?
No, you see, again, like in your introduction, you said that some people are in court to challenge the removal of the Chief Justice. As it stands now, nobody has removed the Chief Justice.
Okay, but no, I'm not talking about the removal, the suspension. I'm saying that based on what you have read as a law lecturer and the somebody who have delved into the Constitution and everything, do you think that the Chief Justice should be removed per what you have read so far?
I have not had the benefit of reading the petition, and there are 3 petitions before the president. I don't have the benefit of knowing which one the president is using or whether he's using the 3 concurrently. I may not be in the position to tell whether or not the Chief Justice should be removed. It is at the instance of the panel that was empaneled by the president to determine whether or not it is right for the Chief Justice to be removed. And again, on the face value, I may say that yes, Chief Justice should be removed. But maybe she had a defense to state why she should not be removed. I am not in that panel. So I may be prejudicing the work of the panel. Let us all wait. When they finish, we will have the opportunity to read whatever judgment or whatever decision they will be arriving at. Then we can critique it as maybe a student of the constitutional law.
So people keep, raising the red flag against her suspension. We have had two applications. This is the second time, and the Chief Justice herself is also doing that. Then after, if Chief Justice become unsuccessful after everything, can she go to court to challenge her removal?
If it will not be on the same subject matter for which the Supreme Court has already determined, she can go. But if she is going to court again to relitigate what already has been litigated, that she will be prevented. We have something we call in law res judicata.
What? Please come again.
Res judicata.
Rest judicature.
Judicata, yes. Oh. Meaning that if two parties have been in court of competent jurisdiction for a matter or an issue to be determined, once that issue is completely determined, none of those parties will be allowed to relitigate that matter. You are debarred, except where you are going on an appeal. If appeal, yes, but you cannot go to relitigate. Maybe because you might have forgotten certain evidence at the trial you could not present, and you are prevented from doing same. So if she will go because of maybe another alleged breach of her constitutional rights, that is okay. But if it is for what has already been litigated upon, that she will be prevented from doing same by this doctrine of res judicata.
Okay, so now we have Justice Bafuboni, Justice Isifu Imore Tanko Amadu. We have Justice Emmanuel Yoni Kolendi and Justice Henry Anthony Kofi, and also we have Justice Yaudakon Asari. People are saying that when you read the background of these justices, there's no way that the Chief Justice will get justice from this. How do you make of it?
You see, all the justices of the Superior Court, they have taken an oath, and they are all there not because somebody has sent them there to do the bid of that person. They are there to do justice, and the judicial oath that is taken is for them to do justice and nothing again. I believe at all material time that these people will be able to do justice and nothing more.
Is the judicial oath are not cosmetics?
The question again.
I'm asking that the judicial oath, are they not cosmetics?
I don't think it is cosmetic.
Because we'll be having a lot of justices giving us a ruling that people think that that rulings are not supposed to be like how it ought to be.
If you think if a party feels that a ruling is not right, the right forum is for you to go on appeal. And so, again, the justices or any justice that gives a decision will actually give reasons behind the judgment that he or she might deliver. So if in the wisdom of a justice, in the law that justice has taken into consideration in arriving at that decision, if you feel that that is incorrect, the best avenue for you is to go for an appeal. And I believe strongly that these are renowned members of this society. These are people who have lived the test of time, and I don't think that they will want anything to jeopardize all the integrity they have reserved for themselves. In this regard, I believe strongly that they will be able to do justice and nothing more.
Okay.
Let us all have faith in our judicial system. Okay. At the end of the day, we will have justice.
Okay.
So that anyone who is going to court will not have to entertain any fear whatsoever as to whether or not that person will be able to get justice. The moment we start to entertain that fear, where people go to court and they think that if it is Raymond who is going to court, the decision will be in this way. If it is Kojo who is going to court, the decision will go this way. Then we are trying to jeopardize our judicial system, and that has certain repercussions on the country as a whole. Because even international community will also become very suspicious of coming to this country to do even investment, and we have to be all careful in arriving at that point. And I don't believe that at this stage the judicial system is at a point where we should be entertaining that fear. They are capable, they will do justice under the circumstance.
Okay. So, Raymond Bidima, my last question. In case you see Madam Esaba Tukono, the Chief Justice, if you see him, you get him one-on-one, what will be your advice to her concerning this case?
My brother, lawyer, you don't advise for free.
You don't advise?
For free.
But what will it be? What will it be?
You want me to give a pro bono?
But what will it be?
No, actually, my brother, I don't think that if I have anything to tell her, I will only say that she should wait. She should hold on, because as it stands now, suspension cannot be translated into removal. She has only been suspended pending the determination of the substantive petition. She should wait after the determination of the substantive suit. If she feels that or she is aggrieved at the decision that has been arrived, then she can now go to court to seek a remedy, so that we can stop all this go and come in court.
All right. So thank you very much, sir.
You are very welcome.
Okay, thank you very much. Yeah, God bless you. God bless you. That was lawyer Raymond Bidima, a law lecturer, a CAF, and I'm what is here in the shortest time I'll be hearing